305, as I started yesterday, has my 6 propositions, seriatim. And my lords had heard me briefly on each of those 6 yesterday.
Yeah.
There is one point I must point out, the paras I have given against each proposition, which are valid.
Right.
Now, the first point I wish to take your lordships to is royalty is a tax. And I've broken it up because I'll be reading less than half of these paras, but lordship will allow me to go in my sequence in that. Because what are the elements of my first proposition? Royalty is a tax. The elements are, number 1, your lordships cannot ignore and must not ignore 366(28). It's a constitutional provision. For ease, it is quoted at my B3 at 325. That's the way I want to proceed. It will be much faster. My B3 at page 325. The elements are that your lordship has an inclusive, which means an expensive definition of tax. In a sense, tax proper and akin to taxes or deemed to be taxes, which are imposts. The characteristics are given in my B3, page 325. Tax or impost, general, local or special. So it's an inclusive, expansive approach. Now, Malads, it is so understood, going back in my para B1, in not merely general cases, but Malads, in extremely important general cases. Para B1 is at page 325. I've given a list of your lordships starting from Shirur Mat, 7 judges. All of them reiterate the famous dictum of a tax by Chief Justice Latham, which is my first para. All of them. I asked myself, which is the element of this missing? None. Is it compulsory? Answer, yes. Is it public authority? And most important, enforceable by law. I know a lordship has 2 queries. One is royalty is not a tax, it's a share or a consideration. Second is it's charged by private persons. Please leave it for 2 minutes, I'll deal with both of them. This Malads chicory is cited by our lordships in 7 judges, 5 judges and 9 judges. 9 judges. Shirur Mat was 9 judges. Jindal is 9 judges, Shirur Mat was 7 judges. Next para cites them. Shirur Mat is 7, Jindal is 9. So Malads, all the elements are satisfied. Now Malads, the case which alone I want to read, I'm skipping, is McDowell in B5.
Yes.
Under 366(20). But this is a constitutional article. How can it be ignored? 366(28). Taxation has been defined to include the imposition of any tax or impost, whether general or local. Impost means compulsory levy, non-volitional, not optional. The well-known and well-settled characteristics of tax in its wider sense includes all imposts. Impost means 1, incident of sovereignty. 2, law means an act of legislature. We know 265 very well, Malas. The term tax under 265 includes imposts of every kind, tax, duty, cess or fees. And the idea of 360(28) is to be expansive and inclusive, not restrictive.
Dr. Singhvi, the problem with your argument is very simple.
Private and...
If your argument is right,
yes,
that would mean that wherever a contract is a statutory contract,
yes,
that it is a contract within the fold of a statute, not just regulated by a contract, but there are statutory contracts. Then any payment which is made under the statutory contract becomes in the nature of a tax. We'll have to go as far as
no, you should not have to. Give me a...
Comes down to that.
No, it will not have to. I assure my lords. Your lordship will have 2 considerations which fell in the open arguments which I was hearing earlier. 1, if it's a tax, how do private people collect royalty? That was one argument against which I am answering in a minute. The second is royalty is not a tax, it's a share or a consideration. The judgment from the Saurashtra, Gujarat. These 2 I'll answer in a minute. Lordship will be satisfied. I've dealt with it. But first, I'm on the elements of a taxation, which McDowell...
The license fee which is paid,
yes,
for the state to partake, or for the state to pass with the privilege of selling alcohol or liquor, it becomes a tax. It's not a license fee by this.
Well, if it's a statutory contract...
Because the state parts with the privilege to deal in liquor.
Yes.
Right?
Yes.
You pay a royalty, you pay a license
I'm going to
fee.
say it's a tax.
It's a tax.
No, I'm not saying it's a tax. If your lordship has, contracts, ultimately, under the law, are contracts, whether they are under the fold of a statute or otherwise. So there will be consenting parties with a contract to which I cannot argue then that that's a tax. I'm going to say it's a contractual fee. There is no contradiction in my argument, whereas it will remain a contractual, consensual payment Somebody will pay 10, somebody will pay 20, longer term, lesser term. It is contractual, it is not tax. The real only two questions against me on this section are the private person collecting royalty, which I'll demonstrate in a minute why it's a wrong argument, and the Saurashtra High Court judgment. I'll deal with them in a minute. So first your lordship has got B5 at page 326. Yes. Clearly the characteristics of a tax are satisfied, absent those two contra points which I'm coming to. Now, on this, my conclusions, if your lordship doesn't mind, are at B13 at 328. This conclusion, as your lordship see, I'm skipping large portions with your lordship's permission. Then I'll deal with those two contras in a minute. May I read B13 at 328? My lords have got it. Royalty and dead rent is a compulsory impost under a statute and not a result of negotiations leading to a contractual agreement. It is unilateral. The mining lessee has no say in its determination. The rate of royalty is fixed by the Parliament in the second schedule. Now, this is a very important characteristic of a non-contractual impost. Your lordship fixes it in the schedule. No options, no discussions, no consent, no negotiation. And can be varied or amended by the central government subject to limitations imposed by 9(3) by a mere amendment. The rate of dead rent, which is actually a more important example, not been given sufficient weight in 9A, is also fixed by the third schedule and can be varied or amended. The recovery is capable of being enforced by coercive means. Your lordships, in that very relic of the past, that contractual exaction of royalty by a private contractor does not have 25 enforceability. Then, hence it is submitted that royalty meets all the requirements of at least an impost. Then, your lordship will come to, may I just straight away take a lordship to the two contrasts which I myself formulated against myself. One is at 328 para 15 onwards. This I have dealt with the Gujarat High Court judgment. Incorrect to characterize royalty as consideration. May I read through very quickly? It will be faster and easier if I read these paras.
Yes, very well.
Royalty imposed under 9(1) ought not to be conflated with the concept of royalty as consideration share of income, such as intellectual property, music, artworks. Such royalty would be determined through negotiations between contracting parties. Royalty in its very essence is based on removal, consumption. There are 9 judges. Your lordship has to lay down the concept one way or the other very clearly. This will endure for a long period of time. And it's very interesting. Let me digress for 5 seconds. 4 months after India Cements, which held it to be a tax. 4 months. Learned judge who was a member of the India, who was heading the bench of India Cements, Chief Justice Venkatramaya as he then was, holds it as 4 months later that we held so, that is the tax. They did not misunderstand their own judgment, It's only the interpretation of Kesoram that you are misunderstanding your own judgment. Now, kindly see. Royalty in its very essence is based on removal or consumption of minerals. Although the terms removal and consumption are not defined, they are linked closely to the terms production and dispatch. These are directly linked terms. Your lordship has them defined 3A, 3FA. I will not read them. Removal, consumption, products, derivative meaning of production or dispatch. I am not reading it for saving time. Now, C customs is a general point. It's not on this. It holds that it is akin to excise. It's 7 judges. 9 judges, C customs is 9 judges. And just see the bold face on the next page, 330. My lord is saying I'm jumping, I'm only going to the highlighted portion. Lord will pardon me. I don't have time to read all. Excise duty is primarily a duty on the production. What is removal? What is dispatch? What is production? What is it, You don't call it excise, but it is in the nature of a duty. Excise is primarily a duty on the production or manufacture of goods produced or manufactured in the country. Next para. Therefore, both excise and sales tax, of course, in different taxable events, are levied with reference to goods. The two are very different imposts. In one case, the imposition on manufacture or production, other is an act of sale. Now, I'm not saying this is a case on mining. It's a general case. It is, now come to Hingir Rampur and the nature of royalty is more akin to that of an excise duty. Hingir, this raises a question as to what are taxes on mineral rights. Obviously, taxes on mineral rights must be different from taxes on goods produced. If taxes on mineral rights also include taxes on minerals produced, there would be no difference between taxes on mineral rights and duties of excise under 84. A comparison of list 1 and 2 shows that the same tax is not put in both the lists. And Malus 50 is a unique entry, it uses the word tax on mineral rights. They don't use the word mineral development, they don't pick up the word for anywhere else. Therefore, taxes on mineral rights must be different from duties of excise, which are taxes on minerals produced. There should therefore be no difficulty in holding that taxes on mineral rights are taxes on the right to extract minerals and not taxes on the minerals actually extracted. This is actually my proposition 4. It's coming later, but the judgment is the same. Thus, tax on mineral rights would be confined, for example, to taxes on leases of mineral rights and a premium of royalty. Taxes on such premium and royalty would be taxes on mineral rights, while taxes on the minerals actually extracted would be duties of excise. And then the last 4 lines underlined, not boldface, last 4 lines, same page. Therefore, the present cess is not a tax on mineral rights, it is a tax on the minerals actually produced and can be no different in pith and substitute from the tax produced. Well, what is the reason in Saurashtra? With the deepest humility, the reason is, if you don't want to have this tax, don't go mining. Well, that's the reason given. Now read my para B20. Every indirect tax, well, in that sense is optional. If I don't go and buy a good, I won't have to pay the tax. So that means I should not buy the good. However, the underlying logic of this reasoning, well, this reasoning is the Saurashtra reasoning, Gujarat High Court. It is respectfully submitted, and that's adopted by Kesharam. That's the problem. Gujarat by itself would not have been a problem, it's adopted by Kesharam. It is respectfully submitted, patently erroneous, in as much as the choice of whether or not to undertake mining operations by obtaining a mining lease cannot possibly take away the character of royalty as a tax, for the reason that this choice is available with respect to all indirect taxes. One may or may not buy goods or may or may not avail services. That cannot possibly make the indirect tax that would otherwise follow something other than a tax. Now, who are the people operating this system? See the next paragraph. From time immemorial, apart from India Cements, apart from 9 judges, this is the Indian Bureau of Mines, which is the mother organization for all this. Royalty in the strict sense and common parlance may not be a tax. It can be viewed as a kind of tax, which is why 366(28).